So welcome back to Legal Brain. Now I'm going to discuss certain areas falling under Competition Act of 2002, and that includes price fixing, bid rigging, and AAEC. So I'm going to discuss one by one. First, I'm going to discuss about price fixing. So what do you mean by price fixing? In simple terms, price fixing agreements are the agreements that directly or indirectly fixes a price, and it will be deemed to be having a detrimental effect, or it will be causing an appreciable adverse effect on competition by virtue of Section 3, subsection 3, subclause A of the Competition Act. So based on this particular section, if the competitors, the sellers, if they are fixing a price, for example, imagine there are 3-4 competitors in the market, and they enter into a price fixing agreements, and they themselves set a price, and which will be detrimental to the consumers. So this is the meaning of price fixing. In simple terms, price is having a broader definition. The word price is having a broader definition, and this price includes not just the final price, it also includes other instances of terms of trade and discounts that have an impact on the final price. So whatever be the price, it need not to be a final price. It can also be other discount prices. So if it is causing an appreciable adverse effect on competition, it is illegal in nature. So price fixing is agreeing with the competitor what price customers will be charged. So purely it's like competitors teaming up, and they are entering into an agreement, and they team up and they fix an agreement and they fix a price. So this is the meaning. This is the meaning of price fixing. So it can also include agreements not to sell something below a minimum price, or agreeing not to undercut a competitor. So this is price fixing agreement. So price fixing leads to inflated prices and customers being overcharged. So this is an important area, that is a price fixing agreements. So in detail, I'm going to discuss about, what are the different types of price fixing. The first category is horizontal price fixing. So in simple terms, horizontal price fixing is the price fixing between the competitors of a particular product. There will be a particular product, and there will be 3-4 players in the market. They will be selling this particular product. So these competitors who sells the same product, they enter into an agreement, and they agree to set a minimum or maximum price for their product. For example, 2 or more competing, fast food chains agree to sell hamburgers for a same price. So they agrees to sell a particular product in the same price. So this is horizontal price fixing. Second one is vertical price fixing. Vertical price fixing meaning is that people from different levels of supply chain, like the manufacturers, the producers, the retailers, the wholesalers, the dealers, the distributors, it is different, levels. People are from different levels. So if there is a price fixing done between these players in the market, then that will be vertical price fixing. This involves an agreement between members up and down the supply chain. For example, an auto manufacturer and its retailers, or the dealers. So these are the examples for the vertical price fixing. Third one is agreement to rise prices. So here in this situation, the competitors will agree each other to rise the price of a particular product for certain time period. Fourth one is agreement to freeze or lower prices. So this is mainly done by, it involves participants such as governments, and they agreeing to freeze price in order, for example, like to stop inflation and to restore consumers' confidence in the economy. They are trying to freeze the particular price. So these are the different types of price fixing, which is seen in market, and this will cause a appreciable adverse effect on competition, and which will be violated. And here I'm going to discuss an important case law, 2018 case law, falling under this particular concept of price fixing. And it is airline surcharge cartel case. This is an important, very famous landmark case law. And the case name is Express Industry Council of India versus Jet Airways, Indigo Airlines, and SpiceJet Airways. So in this case is mainly based on the fuel surcharge charged by these three airlines, in which they formed a cartel and they fixed the price for fuel surcharge. So I'm going to discuss the facts of the case. So the facts of the case is that all these three airlines, they fixed a fuel surcharge for transporting cargo, which is a component of the air cargo price. So they fixed a surcharge. These three airlines fixed a surcharge, and this surcharge was fixed at a uniform rate. That means three of the airlines will be having a uniform, that means same rate, that is rupees 5 per kg. And it was found that the levy of fuel surcharge was introduced as being an extra charge linked to the fuel prices. This was an extra charge which is given by these airlines. And later on, what happened is that this extra charge was linked to fuel prices, whereas fuel charges were reduced. But in correspondence to this, there was no such decrease in fuel surcharge. So even though the fuel prices is like falling down, they didn't reduce the fuel surcharge. So this is a problem. And it was further examined that the fuel surcharge was increased again by these airlines the same rate on the same date. So these three airlines togetherly, they charged a fuel surcharge and they raised the fuel surcharge. So CCA, there was a case in CCI, and the investigation was conducted by the Director General in this regard, found out that there was no admissible evidence of collusion among the airlines, but the conduct of the airlines was not in conformity to the condition of fair conduct. Hereby, what happened is that CCA found this practice is anti-competitive in nature, that is falling under Section 3, and penalized, and these airlines were penalized. So they were asked to give a penalty because of doing this price fixing and by fixing a fuel surcharge. This is an important case falling under price fixing. So next, I'm going to discuss about bid rigging. I hope price fixing is clear for you. So next is bid rigging. So bid rigging is another important area in which is falling under by virtue of Section 3, subsection 3, subclause D of Competition Act. The simple meaning of bid rigging is that any agreement between the market players and enterprises involved in similar production or trading of goods or provisions or services, which is directly or indirectly reduces the competition for bids. So once when we are doing bid, there should be a fair competition in bid. So the thing that is happening in this particular market space is that they're actually creating an agreement. They're forming an agreement. That means any agreement between the market players and the enterprises, they are involving in the similar production or supply or good transaction chain, and they directly or indirectly reduces the competition for bids. So this is again falling under anti-competitive, agreements, anti-competitive nature of competition law, and which should not be done. So Section 3, subclause 3, subsection D of the Competition Act 2002 prohibits such kinds of agreements that result in bid rigging or collusive bidding. So Competition Commission of India, the regulatory authority, has adopted a presumptive, rule approach. In presumptive rule approach, which means that once the essential ingredients which constitute bid rigging has been established, it's enough as there is no further need to find out the impact of such conduct. So in such a situation, the burden of proof has been, lies under the contravening parties to contradict allegations against them and to prove that their conduct was not resulted in any appreciable adverse effect on competition in India. So bid rigging is an essential criteria in which we have to make sure that there is enough competition in bid rigging, and there should not be any appreciable adverse effect on competition in bids. So we have to make sure that there is fair competition in doing bid. And again, there is an important landmark case law, that is 2012 case law, that is aluminum phosphate cartel case, which is a very important case law. And in this particular case law, we call it as re-aluminum phosphate tablets manufacturers case. And in this case, it was held that the bid rigging is a form of practice where all bidders agree among themselves to collaborate the response to the tender. That means, once when tender is calling, these competitors, they team up, they join together, they team up, and they show all these bidders agree among themselves to collaborate and to respond to the tender. So it's basically like they're forming a cartel and they're cheating. And it generally happens during the government procurements, and participants in bids do not compete with each other. They secretly collaborate. They form a secret gang and they collaborate each other and to show their support to one bidder for a particular tender which affects the price. And later, they can share a specific percentage of commission or profit, or they can bid next time as per their secret agreement on different occasions. So this was a case, a very important landmark case law, 2012 case law, and CCA found out that, they have formed a cartel and was penalized. And next is AAEC. So AAEC is another important area under competition law, and that is appreciable adverse effect on competition. So we have to make sure that there is no appreciable adverse effect on competition. So companies with similar products or services compete each other in every market to gain maximum profit. And there are certain situations in which monopolies can be created. A market should not be monopolistic in nature. There should be enough competition in the market. So if if any firm or enterprise is trying to make any appreciable adverse effect on the competition by doing any abuse of dominant position, forming a cartel or so and so, it is punishable. So they ensure better products at cheaper prices. They ensure a wide range of products in the market. They give customers a choice to choose. They ensure consumers' rights are not violated, and they get the best products. So under this appreciable adverse effect on competition in India, which occurs certain practices, like how can we know that there is an appreciable adverse effect on competition? First one is if there is anti-competitive agreements falling under Section 3. Second one is if there is abuse of a dominant position by virtue of Section 4. And if they are doing, some fraud in combination, Section 5. So specifically, especially Section 9A sub clause 3 of the Act states that Competition Commission of India shall take into consideration all or any of the following factors in determining whether an agreement has an appreciable adverse effect on competition by virtue of Section 3. So new entrants in the market are, confronted with barriers like, they are checking whether there is any entry or exit barriers, whether there is a fair combination or not, whether there is any monopoly in the market, the elimination of competition by hindering entry to the market, and then approval of consumer benefits, production, distribution, service improvements, then promotion of technical, scientific, economic development, and so on. So all these kinds of activities, which is falling under anti-competitive agreement under Section 3, is violative of the provisions of Competition Act, and it is causing an appreciable adverse effect on competition. So these three areas are really important and falling under competition law: price fixing, bid rigging, and AAC. That is appreciable adverse effect on competition. So I hope it's clear for you. If you have any doubt, do comment below. Thank you for listening to Legal Brain. Thank you.